MCTV presentation of Law Date is made possible by the Martin County Bar Association.
Hello, my name is Greg Weiss. I'm the president of the Martin County Bar Association. The Martin County Bar Association is composed of greater than 300 attorney members who are dedicated to making sure the needs of Martin County are served in its courts. Every year, the Martin County Bar Association supports Law Day. Law Day was originally founded in 1958 by President Dwight D. Eisenhower to celebrate the role of law in the creation of the United States of America. We continue with that tradition here in Martin County by helping you to find access to Martin County's courts and helping to explain pertinent legal issues ongoing today. There are a series of lectures we've created on family law, foreclosure, admiralty, and access to courts, which we hope will be helpful to you in celebrating Law Day and understanding the role of law in the United States. We thank you very much for your support and hope that we can continue to support Law Day for years to come.
Hello, my name is Trent Steele. I'm the president of the chair of the Foreclosure Law Committee for the Martin County Bar Association, and we're here today to talk to you and hopefully educate you a little bit about the foreclosure process and to answer some of the more commonly asked questions that are presented to lawyers that practice in the foreclosure field. And today I have the honor of having three of what I consider some of the best lawyers in the area to talk about the foreclosure process and to answer some of the questions that we've agreed upon are sort of more common types of questions. So today, joining me, we have Jessica von Valkenburg, who is with the Ticktin Law Group. We have Josh Bleal, who is also with the Ticktin Law Group, and we have Ryan Grazzi, who is with Grazzi and Giannino. Sorry. And like I said, we're just here to answer some questions. I do want to let you know at the outset that if you need more information, be sure to go to the Martin County Bar Association website. There is a brochure that is available that you can download. It looks just like this. You go to the website, and it answers most of the same questions that we're going to be talking about today. Also, if you go to the Clerk of Court for the Martin County Clerk of Court, you can download it from there as well. They have it under Foreclosure Information and Resources. I thought the way that we talk today about the foreclosure process is to talk about it from basically pre-foreclosure to after the foreclosure is over. So the first thing that we're going to talk about is a common thing that happens, and hopefully this is what you will do if you're in the situation where you think you might be going into foreclosure, is go talk to a lawyer beforehand, before you get served with the paperwork, and try to get some advice, because there are some things that you can do ahead of time to prepare for a possible foreclosure or to avoid it altogether. So the first question that I'd like to pose to Jessica here is, if I'm a prospective client and I come to you pre-foreclosure and I'm telling you I think I'm not going to be able to afford my mortgage payment, what should I do? What would you tell them?
Well, I just want to reiterate, Trent, as well, that I do think that's great advice, that no matter what position the homeowner is in, that they should absolutely seek advice of counsel. There are different attorneys that can help with the different options that the person would have when they're in that position. The person could potentially maybe want to mitigate their loss, and they might say, you know, I'm not making it in Florida, I need to move out of state for my job, so I'd like to get rid of this property. Potentially, they could think about doing a short sale. There are certainly there's consequences with a short sale as well. So it's definitely important to seek the advice of counsel so that you can learn of the tax implications and potential money judgment that could be entered against you if it's not done properly. So short sale, for the viewers that don't know what that is, would be where the homeowner would sell their property for less than what is owed on the loan, and the bank, of course, is going to have to agree to that. The homeowner would be seeking, of course, to mitigate their loss and not have to pay the rest of the money to the bank. Another situation where if a homeowner did want to mitigate their loss, they could try to enter into a deed in lieu of foreclosure with their lender, where the lender accepts the property back and agrees to forgive any sort of deficiency. Those things are not very easy to do, and a homeowner can certainly spin their wheels. So again, counsel would be a great option to seek at that point. Also, for those homeowners who want to try to save their home, there's things such as loan modifications, also sending out qualified written requests to get validation of the debt so that the homeowner can have some guidance there. So I certainly would recommend seeking counsel to try to nip it in the bud, as you would say, for foreclosure action, or be prepared for if they were actually served in foreclosure.
Great, great. And once again, don't forget the Martin County Bar Association website. The qualified written request, which is important, is in the materials. So if you want to download it from there, it is something that I think is really important for people. It's a way that you can find out who actually owns and holds your note and mortgage, which you may think you know, but in many cases, as we know, we don't always know that situation. So let's say that the homeowner isn't able to do a short sale or a loan modification. They aren't able to get the deed in lieu, and they get served with the foreclosure lawsuit. Process server comes and knocks on the door and hands them the paperwork. Ryan, what should they do at that point?
Well, the first thing that should be done, and again, you'll probably hear it a couple times, is seek advice of counsel, because that there are certain time restraints that are very important, and it's important just to know your rights and know what obligations you have to comply with in order to not be defaulted. The summons will explain some of the information, but it generally gives you 20 days to respond to the plaintiff's complaint. And so you have that time to seek counsel and seek what other avenues that you want to take, and some of the things that Jessica touched on.
Any things that you shouldn't do, that a homeowner shouldn't do if they get served with a lawsuit?
You shouldn't ignore it. That's probably the biggest thing.
Right.
A lot of times I get people coming in that send just a regular letter to the court saying, I don't make enough money and I can't afford my mortgage and please don't kick me out. Unfortunately, that's not a viable legal defense, and I've been in court a number of times where the judge has read that letter from the homeowner and said, unfortunately, it's not a legal basis to stop the bank from getting their judgment, and you should seek counsel. So that's definitely what should be done, is seeking the advice of counsel and seeing whether or not you want to pursue the avenues to defend the foreclosure, or in other cases not defend the foreclosure and go some alternative route.
And once again, I'm going to be talking about this a lot today. In the materials on the website, there is, if you can't afford to get an attorney immediately or you need more time, like Ryan was saying, don't send a letter. I gave you a form in the materials, or we did, the Martin County Book, a form for a motion to request an extension of time. Get that in within the 20 days so that even if you can't get to see an attorney beforehand, you at least protect yourself, because you don't want a default being entered against you. So I think that's important. Okay, so you've gotten served with the lawsuit, and it's kind of a scary time, I think we all know, for the homeowner. They don't know what to do. They don't know what to expect. And that's another common question I think that we all get. Maybe, Josh, if you could explain a little bit about, well, what happens next, because that's what homeowners want to know. How soon am I going to have to move out of my house, and what's going to happen?
Right, Trent. And those are common questions we get, because it's very disturbing. When someone comes and knocks on your door and gives you a summons, if you haven't dealt with the issues like Jessica talked about beforehand, now the reality is setting in. So if you haven't done anything when that lawsuit comes, now is your time to act. So naturally, the analogy I like to use sometimes is, if you do nothing, it's like showing up to a baseball game where the other team doesn't show up. The umpire's going to say you win. And in a vast majority of cases, especially right here in Martin County, this is oftentimes how the homeowners are being divested of their property. It's very easy for the bank to say, well, the homeowner got the lawsuit, judge, they didn't show up. Obviously, they don't care what happens. And the judge is not in a position to say, well, hold on, let me be an advocate for the homeowner. The judge is the neutral decision maker here. So even if the judge were inclined to be an advocate for the homeowner, they're not going to step out of that position. So what happens is if you do nothing, you've pretty much sealed your own fate, and the case will progress more quickly than as if you've defended it. So what happens is when you hopefully are seeking the assistance of an attorney here, this attorney is going to start with you and say, okay, what's your plan, what's your strategy? Because as a litigator, every one of us, which we are, you say, okay, what are your plan and what are your goals? And so you set those goals out and you work with your attorney and say, here's what I want to achieve. Oftentimes we hear in the paper these days that homeowners are delaying foreclosures. You know, as an attorney, it's unethical to file paperwork simply for the purpose of delay. But what one needs to understand is that by asking for documents, by litigating the case, i.e. testing the bank's case, and at the same time also building your case as a homeowner, that's going to take some time. That's not delaying. That's litigating a case and working it out. So, you know, a lot of times the homeowners think they're going to get this knock on the door in the middle of the night. And, you know, once you go to talk to an attorney and they lay out these timelines about the hearings that have to occur, their discovery requests, are you asking the bank for paperwork, maybe the bank asking the homeowner for some paperwork, and vetting out these issues, I oftentimes find, more often than not, that the homeowner has some kind of a feel that now, while they may not be in control of the actual litigation, at least they're aware, and knowing is half the battle here, to use one of those coined phrases.
Right. Well, assuming that they do nothing, assuming they don't go to an attorney, how long do they have in their house, would you say?
It could be as short as a couple months, and that's a sad part about it, because think about it from the bank's attorney's perspective. If they've got a homeowner that's actually litigating the case with a trained attorney on the other side, vetting out these issues of who owns and holds the note, was there predatory lending, it's going to take much longer for that plaintiff and that attorney to proceed with that case. What I oftentimes see is that it's the homeowners that don't raise their defenses, that don't respond to the complaint. When they get served, they put their head in the sand. You know, just from a practical standpoint, those are the cases that are going to progress much faster, because it's easier to move that case through the system when you have no opposition.
Right, right. Another thing that I'd like to point out is that for those of you who think you can't afford a lawyer, many lawyers work on a variety of different types of payment plans, and they try to work with homeowners that are in distress. So before you think that you can't afford a lawyer, call around and talk to a couple of different people. And also, but if you find that even you can't afford the payment plan, there is also available here in Martin County, Florida Rural Legal Services, which provides legal help for low-income individuals. If you're a veteran, you can go to the VA, and sometimes they can provide services for you, legal assistance, especially for those that are on active duty. So don't forget about those resources as well. Let's see. I think next, let's go to Jessica and just talk about some of the defenses that do and don't work with the court, some things that, and why it's worthwhile to even bother defending a lawsuit. I mean, you haven't made the payments, you're in default. I mean, what right do you have in those situations?
Well, I'd like to start with the ones that don't work, and I think Ryan touched on it. Just sending a letter in saying, oh, I can't afford my mortgage, the bank won't work with me, help me. While that may be true, and that might be the situation, and unfortunately a lot of homeowners are dealing with that, it's not a legal defense to the foreclosure action. So, and I think that Josh also touched on it a little bit, basically testing the bank's case. The bank, as the party bringing the lawsuit, has to prove their case against the homeowner. So they do have to produce certain paperwork, such as the original contract that the homeowner signed, and support for obtaining a judgment against the homeowner. So the homeowner can test, and again, I would recommend going through counsel.
Sure.
Certainly everybody has the right to represent themselves, but I think in this stage, to really present your legal and what we call equitable defenses to a foreclosure case, you'd want certainly the assistance of counsel. So we would have, of course, the paperwork issues, but really, I think that it takes a little bit more digging into, as Josh was talking about, vetting your case and finding out what really happened, let's say at the origination of the loan. Did the bank act in a way that was unclean? There's an equitable defense available to homeowners called unclean hands. And essentially what that is showing the court is that, you know what, the bank isn't here as a victim. They maybe acted improperly. So those are some defenses that really would take some some digging and getting some information, and usually through counsel that would be helpful in defending a foreclosure case. It's not just open and shut. You don't pay your mortgage, you lose your home. That's not the way that it works.
Right. And that's the thing I think that we all need to remember is that in the last 10 years, the process of borrowing money to buy a house has changed dramatically and has become a lot more complicated than it used to be. Banks change hands frequently, promissory notes get bought and sold, and there are situations where you may be in default, but the wrong party is bringing the lawsuit against you, and I think that that's something that's important. Let's change course here just a little bit and talk about some other issues that come up, that a common question that I think that we probably all get, which is, if I can't afford to pay my mortgage, should I pay my homeowners association or my condo association dues? Ryan, what's your feeling about that?
Well, our firm represents associations as well, and the answer is absolutely yes, because the defenses that you may have to your mortgage foreclosure are probably not going to be available to the association lawsuit. And a lot of times the association can move a lot faster than the mortgage foreclosure. The bank foreclosure that could take 3 to 6 months if it's moving quickly can be done in 2 to 3 months if the association's moving slowly. So it can go a lot quicker, especially if you're living in the house. You don't want to take that risk, and it's definitely better to pay the association because they can absolutely move faster than the banks. They're a lot smaller, and they can transmit the information faster, and they can get through the courts a lot faster. In mortgage foreclosures, they're over 15,000, so they're in circuit court, where the thousands of other mortgage foreclosure cases are, and in most instances, the associations are going to be under 15,000 and be in county court, and it's much easier to get a hearing, and the cases can move much faster. So, and again, you don't have all the viable defenses. When you bought the property, you knew that it was going to be in an association. You knew that dues were going to be due, and you have to continue to pay those. If you're not living in the property with the HOA, perhaps you could reach out to the association and strike a deal with them where you can either give them some sort of authority to rent the unit and pay the dues through the rent. That's a common theme right now with the associations is getting a tenant in the property so that money is coming in monthly to keep those dues down while you fight the foreclosure.
Okay, but let's talk for a minute about renters and renters' rights. And frankly, let's say that you've got a house in foreclosure and and you are renting it to someone. You've moved out, but you've got a renter in there yourself. Can you talk, Ryan, a little bit about what the rights are of the homeowner who's renting a house that's in foreclosure and the rights of the tenant who is living in a house that is being foreclosed upon?
Sure. The recent legislature was the Protecting Tenants at Foreclosure Act, which basically breaks down to 3 different areas. The first is if you entered into a lease with your tenant prior to being served with the foreclosure suit, the lender has, or whoever retakes the property at the end of the foreclosure, has to abide by the terms of that lease. If you entered into the lease after the lawsuit was filed, then it changes, and after the foreclosure sale and the eventual purchaser takes title, you have the tenant will have 90 days after notice to either to vacate the property, and that is unless the purchaser at the foreclosure sale intends to use the residence as their primary residence, in which case they basically have to move out after you can acquire a hearing to get a writ of possession, which all writs of possession require a motion and a hearing in front of the presiding judge.
Now, talk about let's say that I've got a house and I've got a tenant in there. The tenant got served with the foreclosure paperwork and says, I'm not paying the rent anymore. What are my rights in that situation?
Well, in Florida, you own your house. Florida is a deed state where you have the deed, the mortgage is a lien. So as long as you still have the deed to your house and it hasn't transferred by way of certificate of title at the end of a foreclosure sale, then you have control over the property. And you can rent that property to whoever you want. That tenant has to continue to pay rent, otherwise he can face being evicted. There are some cases where the mortgages did an assignment of rents provision, mostly found in commercial cases, occasionally in residential cases. In that situation, it may be different. But generally speaking, residential mortgages do not have that provision in there, and so the tenant has to continue to pay rent, otherwise they could be evicted.
Okay. All right. So we've talked a little bit today about what to do to avoid foreclosure, what to do when you're in foreclosure, and what your rights are. And I wanted to sort of end with talking about those situations where you've already been foreclosed upon, and you may think that something wasn't right with the foreclosure process. Do you have any rights? And I was hoping maybe, Josh, you could talk for a little bit about is there anything that can be done, or is it just too late once the house has been sold and taken away?
Yeah, Trent, this is exactly why we're here having this panel discussion, because these are oftentimes things homeowners aren't aware of. Oftentimes a homeowner will think, well, okay, and I've heard lenders tell homeowners a number of different things, most of which I have a tendency to believe because I've heard so many times. Oftentimes a lender will say, don't worry, we'll work with you. We're not going to cancel the final hearing. We'll work with you afterwards. Well, take into consideration as a homeowner, you're essentially relying on your adversary to give you that advice. It's not a good position. But what happens in a foreclosure is that generally at some point in time, if you haven't defended the case, there's going to be what's called a final judgment. Once that final judgment is entered, case closed for all intents and purposes. And it's very difficult as an attorney to go in and say, well, Judge, you know what, there was something wrong that happened in the case, and I want you to get rid of that decision you made. Let's go back to the beginning. An analogy that I often use is that, people are familiar with the criminal system. It's like a judge convicting you of robbing the liquor store. And the judge says, okay, Mr. Blau, you're going to go to jail for 3 years. And the judge has already made the determination that I'm the guilty party. And then after I've been found guilty, I say, Judge, but it wasn't me. It was someone else. The judge is going to say, well, that's all fine and dandy, Mr. Blau. You should have raised that whenever you had your trial. You had every chance to defend yourself, and now you hadn't. So really what it's trying to do, it's trying to unring that bell that's already been rung. That's why it's so important at the outset, when you see the problem coming, reach out to those people, those entities, those organizations that can provide you the guidance, because once that final judgment's entered, for all intents and purposes, it is case closed.
Okay. Well, I want to take an opportunity to thank everybody that's here. Again, Ryan Grazzi, Josh Blyle, and Jessica von Valkenburg. And I'm Trent Steele, president of the Martin County Bar Association Foreclosure Law Committee. Again, the one thing that I think that we probably all experience with people that come in that are facing foreclosure is they have a sense of almost embarrassment or shame or putting their head in the sand, which is not. You have rights in a foreclosure, and I think it's very important that you understand what those rights are. There are people, there are judges that are in foreclosure, there are lawyers that are in foreclosure, there are doctors that are in foreclosure, and this is nothing to be ashamed of, and don't, just because you're in default doesn't mean that you don't have rights, but the only way that you're really going to find out what those rights are is by talking to a lawyer. But until you can get to see the lawyer, I'm going to do it one more time. Don't forget to go to the Martin County Bar Association website or the Martin County Clerk of the Court website and take a look at the foreclosure information and resources handbook that we prepared, just to give you a little bit of information. And if you have any questions, feel free to call the Martin County Bar Association, and they can direct you to either this or and there are phone numbers as well that are listed in the handbook. So once again, thank you, and we appreciate the opportunity to be of assistance during Law Day or any other time of the year. Thank you.
MCTV presentation of Law Date is made possible by the Martin County Bar Association.